Stream starting now.
Great, then I'm going to call this meeting to order. This is the August 1st, 2024 meeting of the Planning Commission. Can we have a roll call, please?
Member Reland,
Here.
Commissioner Smith.
Here.
Commissioner Lucero.
Here.
Commissioner Mirando, excused. Commissioner McGee. Present. Commissioner Lawrence
Here.
and Chair Clow.
Present by Zoom.
Thank you. You have a quorum.
Thank you. Next, we have the Pledge of Allegiance. Commissioner Smith, will you lead us in the pledge? Next, we have approval of the agenda. Were there any changes from staff?
No, Chair Lawrence.
Any changes from the commission? And if not, can I have a motion to approve?
Second.
Can we do a roll call vote? And just to be clear, Chair Clow will be voting and I will not be, as I'm managing the meeting.
Thank you, Chair Lawrence. Commissioner Reland,
Yes.
Commissioner McGee. Yes. Commissioner Lucero,
Yes.
Commissioner Smith.
Yep.
Chair Clow.
Yes.
Thank you. The motion has passed.
Thank you. Next, we have approval of the consent agenda. There is one item on the consent agenda. Is there anything either from staff or the commission, or is there a motion? And that would be a motion to approve the consent agenda.
So move.
Commissioner Reland,
Yes.
Commissioner McGee. Yes. Commissioner Lucero,
Yes.
Commissioner Smith.
Yes.
Chair Clow.
Yes.
Thank you. The motion has been approved.
Great. Next, we have approval of minutes. First, the minutes from June 6th, 2024. Was there anything from staff on those minutes?
Commissioner Lawrence, I didn't have any changes to the minutes, but I did want to say a personal thank you for taking a look at them and helping us out. We are still down a stenographer for these meetings. And so we are, trying to, get those minutes done and on time, but it is definitely not what we are. I'm a terrible note taker. I'll just say it.
Probably
we're
not in
trying.
your job description.
It's not in my job, and I hate that term, but yeah, it's not in my skill set either. But I do thank you for that, and so we will continue to try to get those minutes to you for review, and appreciate your support until we get a permanent replacement.
Thank you. Appreciate that, and I'm happy to help. Is there anything from any commissioners on the June 6th minutes, or can I have a motion?
Motion to approve.
Second. Commissioner Reland,
Yes.
Commissioner McGee. Yes. Commissioner Lucero,
Yes.
Commissioner Smith. Abstain. And Chair Clow.
Yes.
Thank you. Motion has passed.
Okay, next we have the July 11th, 2024 minutes. Was there anything on those minutes from staff? Anything from the commission? Thank you. And if not, can I have a motion on the July 11th minutes?
Motion to approve.
Second. Commissioner Reland,
Yes.
Commissioner Yes. Commissioner Lucero, Commissioner Smith. Chair Clow.
Yes.
Thank you. Motion has been approved.
Thank you. That moves us on to approval of the findings and conclusions for case 2024-7751, the Meridian Las Saleras Medical Center sign height variance. Anything else on those findings and conclusions from staff?
No, nothing else from staff.
Thank you. Anything else from the commission or a motion?
Motion to approve?
Second. Commissioner Reland,
Yes.
Commissioner McGee,
Yes.
Commissioner Lucero, Commissioner Smith, Chair Clow.
Yes.
Thank you. The motion has been approved.
All right, thank you all. That takes us all the way down to staff communications. Ms. Manuk Herman, I think that you're listed on the agenda.
I'm sorry, I'm trying to get the agenda because my laptop's not, is there just one finding of fact on the
There-
agenda?
There is, let me
We
see if
did
it
both
has
of them?
changed since I downloaded it.
Okay.
But
Okay, I'm just trying to remember and I don't want to move on if we're, yeah.
No,
Thank you. Yes, Commissioner Reland is looking online and confirming that there's only one.
Oh, good. Okay, thank you so much. I'm so sorry. Yeah. Okay, good. Right. Okay, then, yeah, we're ready for. Yeah, so thank you for coming in tonight. When we don't have any new cases on the agenda, for this training. We offered this to the Board of Adjustment, a few months back. And, wanted to offer this as well to the planning commissioner since we have some new folks and, new members. And I just want to say too that, several years ago when I started, we invited some city staff, some experts to come and present on water planning and development, on transportation planning and on transportation and infrastructure issues, on affordable housing. And so we are going to be, kind of doing another series of trainings, through our agendas over the next several months to bring, this additional information to you so we can have, conversations on these issues outside of discussing them in relation to specific developments. And so that's going to be happening. We are also, as well, kind of entering the kind of final phase or final stages of phase one of the code adoption. And so, we're working on an adoption timeline and we'll be holding some new engagement with the public, a couple of new public meetings. And of course, we're working with the Planning Commission Policy Subcommittee. So those are also kind of other, things that are going to be happening over the next several months that, will be coming before the Planning Commission. Okay.
One other item. Thank you, Chair Lawrence. With reference to the Built for the Future series that we're having for the community, the next one up is Built in the Past. And it's relative to historic preservation and archaeological review. And so we'll be doing that session the second part of October. Just mark your calendars. We'll let you know. And we're going to have a series of different topics over the year on a seasonal quarterly basis to have that outreach with the construction.
So I'll go ahead and start the presentation. So this presentation is going to be mostly focused on conduct protocols and ethics issues. The governing body does an annual review of the Code of Ethics. And so as part of that, we usually do a training from the city attorney's office. So in addition to having a lot of the information from the Board of Adjustment presentation, this also contains some of the recommendations and kind of issues that we discussed during the governing body training session as well. The governing body does have some different types of ethics issues and different rules because they're elected officials. They're in kind of a different position than members of the Planning Commission are, but they also hear quasi-judicial hearings. And so some of the issues that come up are similar to the ones that you might be facing in your roles as planning commissioners. So specifically the topics I'm going to be covering this evening are the Open Meetings Act, ethics and rules governing conduct, and the Inspection of Public Records Act and kind of how that impacts the Planning Commission. So with respect to the Open Meetings Act, let's see. So a quorum must be advertised beforehand, and the public meeting must, and the public must be invited. Sorry, the print's not great on this. Sorry about that. The colors don't look as good on this screen. Um, but I just, these are some general rules for complying with the Open Meetings Act. All action items have to be noticed at least 72 hours ahead of time. One thing to be careful of is rolling quorums. And so rolling quorums are what happens when basically a quorum of commissioners or members of a land use board end up discussing public business, not all in the same place and at the same time. So it's just something to be mindful of because that can happen over a few days, over email. So if three planning commissioners are discussing an item over email and then forward that email to another member and then forward it to, it's that addition of other members that can cause it to be a rolling quorum and therefore subject to the Open Meetings Act. And so you just want to be careful with discussing matters that might be public business, such as a land use case or something pertaining to a land use case in situations that might potentially lead to a quorum or might lead to a quorum of commissioners discussing it. Ethics rules, the City of Santa Fe's charter, section 2.01 calls for a code of ethics, and the city's ethics code is codified by city ordinance, and so it's available online. You can access it by going to the city homepage, your government, Santa Fe Municipal Code, Chapter 1, and then it's 1.7 Code of Ethics. So we have a Code of Ethics policy, and the policy is as follows. The proper operation of a democratic government requires that public officials and public employees be independent, impartial, and responsible to the people, that governmental decision and policy be without conflicts of interest, that public office or employment not be used for personal gain, and that the public has confidence in the integrity of its government. So the purpose of the Santa Fe Code of Ethics is expressed in section 1-7.3. The purpose is to fulfill the obligation imposed on the governing body, on basically people who are going to be making official acts by the Santa Fe Municipal Charter to establish standards of ethical conduct for public officials, employees, and provide consequences if violated. And so I'm sorry, I had a reference to the governing body there, but really what we're talking about is people who are making official acts, which you do when you take any kind of official action as a planning commissioner, any type of vote. Purposes also include to adopt standards to make decisions without consideration of personal benefit, to provide clear guidance as to what is allowed and what is not allowed, to advance openness in city government through disclosure, and to exercise legislative powers granted under the state constitution and adopt a code of ethics to meet local concerns and the needs of Santa Fe. And again, that applies more to for legislative powers. The Planning Commission doesn't really exercise any kind of legislative function. It's all quasi-judicial. But the idea is to meet the local needs and concerns and to have processes that are open and fair and that are also perceived that way by the public. One important issue for ethics is conflicts of interest. So conflicts of interest are defined as a specific and identifiable prospect of pecuniary gain or loss other than a gain or loss that is de minimis in amount or shared with a substantial segment of the general public to any of the individuals or entities here listed from an official act of any public official or employee. And so types of conflicts can include financial benefits, family, and issues that are affected by official acts. So financial benefit is defined as any money, service, license, permit, contract, loan, travel, entertainment, gratuity, or any other thing of monetary value, or any promise of these. And family members include members of the individual's household, his or her children, even if they don't live with you, stepchildren, brothers, sisters, parents, step-parents, domestic partners, and all persons claimed as dependents on the individual's latest federal income tax return. So, and then an official act is defined as an official decision, a vote, approval, and any acts that involve the use of discretionary authority. So if you're going to be voting on voting on any matter, and that matter involves either family or a financial benefit, those would be considered conflicts of interest under the city code. Additionally, one has a conflict of interest if so not every action that benefits the public creates a conflict. So it's not a conflict if gain or loss is de minimis in amount, or it's a gain shared with a substantial segment of the general public. So for example, if you were involved in drafting legislation that would reduce taxes for all the citizens of Santa Fe, and you're a citizen of Santa Fe. So it would be hard to think of an act like that for the Planning Commission, since typically you're not involved in drafting legislation in any kind of official capacity, but just if it's something that benefits the general public. So for example, if you're, you happen to live in Santa Fe and you approve and you recommend approval of a rezoning in the city of Santa Fe, that's something that, could have broad impact on the city of Santa Fe potentially, but as a citizen of Santa Fe, that doesn't necessarily, a resident of Santa Fe, that doesn't necessarily create a conflict of interest.
Ms. Manu-Kerman, can I just interrupt to
Yes.
clarify? Occasionally, the Planning Commission does get involved in legislative actions, but in a means of making a recommendation to
Right.
the government body.
Okay,
So
yeah.
in that case, would some of this apply even in the case of a legislative recommendation?
So I guess legislative, okay. So you mean legislative, like if it were a recommendation to amend the general plan or something like that, or a recommendation to
Well,
adopt an ordinance for rezoning? something like that?
An ordinance, for instance, the Planning Commission a few years back was involved looking at the short-term rental ordinance and recommended changes. So that would be
Okay.
a change to ordinance.
Great. Yeah, I wasn't thinking about that. So yeah, so that would be something that wouldn't pose a conflict of interest just by being a resident of Santa Fe and being involved
Thank you.
in that. So thank you for raising
And
that.
just at part of your presentation, are you okay if commissioners have any other questions along the way?
Yes, absolutely.
Thank you.
Types of things that would create a conflict or any act likely to result in financial gain or loss to the list of entities on the preceding page. Some examples would include any employer, client, or customer from whom you know or reasonably should know paid you or a family member more than $500 during the year preceding the official act. And so an example of this coming up, this type of conflict would be if you were paid $501 to provide catering services during an event, but then the restaurant that paid you is now seeking a variance to expand the restaurant. So then your involvement with that variance would be a conflict of interest. Involvement in a civic group, labor union, or social, charitable, or religious organization can also create a conflict of interest. For example, if you are on the board of a nonprofit that purchases land for purposes of preserving it as undeveloped land, but then the nonprofit comes before you with a request to amend a subdivision plat to further that purpose, that would also create a conflict of interest. Improper gifts can also create conflicts potentially in quasi-judicial hearings. So this can come up a lot of times. So this could potentially come up, very innocently. I guess an example I was trying to think of so basically, if you receive gifts over $50 are kind of considered improper gifts if they come from someone over whom you have some kind of direct official authority. And so kind of an example I was thinking of is like I have a 2-year-old at home. So a lot of times people that I don't know very well, like neighbors, kind of see us around the neighborhood and they'll offer, like things that are just big in their house and are taking up a lot of space. Sometimes they're kind of expensive things and they don't really know us, but they'll be like, do you want this stroller or this like, remote control car, just to kind of get rid of it. And so if something like, but then if you were to receive a gift like that, but then that person were to come before you with a development plan, some 6 months down the road, that's the type of thing where that gift might look differently now that that person is coming before you with a potential project that you then have to approve or disapprove. And so that might be a reason to potentially recuse, and it would potentially become an improper gift under those circumstances. So you could receive an improper gift and not necessarily know you did until later down the line, but it could create a basis for recusal.
There a value limit to that? Or,
So generally it's about $50. So gifts in excess of $50. Yeah. Honoraria is also can also create an issue. And so honoraria would be a payment for some kind of a speech or other public appearance that you give in your role as a public official. So if you give a speech and say, I'm here as a planning commissioner, you would not be able to receive compensation for that speech. The appearance of impartiality is as important as actual impartiality. Types of things that can cause the appearance of impartiality are often the types of things that could create a conflict of interest, including things that might benefit you or your business, benefit a family member or a family member's business, benefit a civic or religious group that you're involved in, or a case involving your specific neighborhood. Ex parte communications can also create conflicts or the appearance of impartiality. When the commission acts as a decision maker on matters affecting people's property interests, commissioners have to be and appear to be impartial. Any conflicts of interest or apparent conflicts of interest have to be disclosed prior to the hearing. So, if you're at the meeting and you disclose the conflict in the open meeting, that's the appropriate way to do it. You don't have to make sure it's done, before you even enter the room, but it can be done on the record before the actual public hearing starts. The commission's decisions have to be based on the evidence and testimony presented at the public hearing. And this is to assure that all members are basing their decision on the same information. Ex parte communications are any communications that occur outside the context of the public hearing that are related to the matter at hand. They can include written or verbal communications, independent investigations, or site visits. So don't, if you have a case coming before you, don't go do a site visit yourself. Don't go drive by the property or walk through it. Don't reach out to people that, might know something about the property. If you do receive emails about, a case that's going to be coming before you, what you can do is you can send those emails to land use staff and we can address them. Otherwise, we can also send you some form language if that would be helpful to, if you feel like it's necessary to give that person a response, but let them know kind of what your role is in the case and why you can't really get substantively involved in it. Due process is also one of the factors or one of the guiding principles in kind of determining, what kind of communications are proper and how what is and is not allowed to be heard during a meeting. The guiding principle for due process and quasi-judicial administrative hearings is that interested parties in a quasi-judicial zoning matter or matters in general, this is some case law about a zoning matter specifically, are entitled to an opportunity to be heard, to an opportunity to present and rebut evidence, and to a tribunal which is impartial in the matter. So having had no pre-hearing or ex parte contacts concerning the question at issue, and to a record made and adequate findings executed. So it can also play into due process. the matter of being impartial and only receiving evidence during the hearing when everyone is able to access that information. With respect to bias claims, which can come up following a decision, a quasi-judicial decision. Our Court of Appeals has held that where a due process violation claim is based on alleged bias on the part of the fact finder, as the Planning Commission usually is, the inquiry is not whether the fact finders are actually biased or prejudiced, but whether in the natural course of events, there's an indication of a possible temptation to an average person sitting as a judge to try the case with bias for or against any issue presented. So even if you were in a situation where your brother came to you with a land use case and you really knew that you could be impartial, the appearance of that impartiality would be such that it could compromise the outcome of the vote. So when the Planning Commission is making decisions, there are some things that should be considered and some things that should not be considered in order to reach a valid result. Things that are to be considered are all of the applicable criteria, such as those in the code for a rezoning, a variance, anything that might come before you. A lot of times there are criteria that are listed that are very specific. Sometimes they're less specific, but whatever those criteria are, those are always appropriate to consider. The general plan is often appropriate to consider, or other applicable plans. And deviations from criteria should probably be addressed in findings. So specifically, if something does not meet criteria, then it's good to address that in the findings so that there's a clean record of why the commission voted the way it did. And so usually the person making the motion would be the person to address that in the findings, to say what criteria were and were not met. Things that are not relevant to a decision include who the applicant is, such as if they were a released felon or a local charitable donor, someone who other factors that are not relevant, or who opposes the application, who supports it, and how many of each testify, and any other information not in the record at the hearing. Items can be postponed if new information requires further deliberation, if there's insufficient time to hear all testimony, or additional research is required. So a lot of times this comes up here if, for example, you really feel that fire needs to weigh in to determine if a proposed development is safe, for example, and we don't have fire available to weigh in. So that might be a time when you'd want to postpone a decision on the matter so that you can get all the information that you need.
Could I ask a question?
Yes,
Go back to that slide.
yes.
Is additional research is required? Is that the counter to information not on the record at the hearing?
Right. So if you do need additional research, it needs to be part of the record generally. So if you need, for example, additional research from planning staff about a project, like if you need to know, how high a hill is or something like that, you should ask planning staff to get that information for you. Does that answer the question? Okay. So what to do if you have a conflict of interest? You should disclose it. The Governmental Conduct Act provides that full disclosure of real or potential conflicts of interest shall be a guiding principle for determining appropriate conduct. And often the answer is that if there is a conflict of interest, you may want to consider recusing. It is always your choice whether or not to recuse, but just be mindful that in a quasi-judicial proceeding, the parties are entitled to a neutral adjudicator and to the appearance of impartiality. So often it's the most fair thing to everyone who's involved in the case to recuse if you feel that your involvement in a case would cause the appearance of impartiality or an actual unfair result potentially. If you do recuse yourself, the protocol is that you leave the room and wait for the item to be done. So it's not just recusal from the vote, it's usually recusal from the item altogether. So all of the public comment and presentation on the item as well. So
One question.
yes.
So technically, if we're recusing ourselves, wouldn't we become part of the public at that point? So why would we have to step out of the facility?
So I think that that's our protocol. And I think that the idea is that, if you're still present in the room, you could still potentially impact the proceedings somehow just by body language or, if it was something that you were very, very close to. And I mean, the other commissioners might feel uncomfortable potentially, voting in a way that negatively impacts that project or whatever it is. So I think that's the idea there, is that like if you do have to recuse, you remove yourself from the room so that you're removed kind of entirely.
Ms. Manuk Herman,
Mhm.
what should people do if they are not sure whether they have a conflict of interest or not? If there is something that they think might be borderline, or that they're not sure whether or not it falls into the realm of an actual conflict? Because this is a fairly small town.
It is, yeah. So one thing you can do if it's before the hearing is you can let me know about it. You can always email me or call me to ask, and we can discuss. You can have privileged conversations with me or anyone from the city attorney's office. So if you have a potential conflict of interest, that's probably the easiest way to deal with it so that we can discuss it and try to make a decision before the hearing. If we're actually in the hearing room and you don't realize it, like it's a member of the public that appears in the room that is going to be testifying or something like that, and you realize it's somebody you know or a close family member or something like that that could impact your decision. We could still have the opportunity to take a break and chat for a minute. That would probably be the best thing to do if you feel that it's necessary. If you really just feel kind of conflicted about it and don't know if it would impact your decision, but feel that it likely could or could cause the appearance of your decision being impacted, then it's probably a situation where you would want to recuse.
On the previous slide, and several other times, you've talked about the appearance of impartiality as if that was a problem as opposed to the appearance of partiality. And I'm just wondering what are the distinctions you're trying to make?
And I guess, and I'm sorry about that. I mean, I guess that's I'm misspeaking on my part. It is important to appear impartial. You do not want to appear partial in a case.
But
Does that make sense?
actually, it doesn't, but that doesn't mean you're wrong, right, and I'm wrong.
Okay.
I'm right and you're wrong. The appearance of impartiality could be faking it.
It could be.
I mean, being impartial is what matters. It's
Yes.
to me.
They're both important. I think what it's getting at is that if you are actually impartial, but you appear partial, that's when it's a problem. Because that's the standard in court, is if a person looking at it would say, you appear to be partial, even though you're not. So I guess the example would be, if it's your brother's business and you're approving the question is, would you, approve a project that affects your brother's business? I mean, even if you could remove yourself from it and be impartial and make a completely well-reasoned decision, you would still want to recuse in that circumstance, probably because you would appear to be partial. Yes, please do. Please ask me to clarify if I say something confusing. Thank you. Okay. And so then the last section I had was just about the Inspection of Public Records Act. And so it's just something to be aware of. I know that commissioners don't generally deal with the Inspection of Public Records Act requests directly, but documents created by the commission can be subject to the Inspection of Public Records Act. IPRA is the acronym. The idea of IPRA is that the public is entitled to the greatest possible information about government affairs. The public has the right to inspect. Providing records is responsibility of all public officers and employees, and requests would come through the city. And so we do have a specific IPRA staff that handles those requests and then sends requests out to people who might have relevant information. Generally, you should assume that everything related to a public case is going to be IPRA-able unless it falls under an exception. So there are several exceptions for IPRA, including records pertaining to physical or mental examinations, letters of reference, certain letters or memorandums of opinion and personnel files, portions of law enforcement records, generally things that aren't going to be applying to the Planning Commission. However, the one that may come up is attorney-client privileged information. And so generally, if you do have any attorney-client privileged information, such as communications with me, that's generally not going to be subject to IPRA, as long as it's privileged, meaning like it's related to or seeking legal advice. That said, confidential information should also be kept confidential. As a lot of you probably know, if you are the client in an attorney-client relationship, generally the privilege is the client's to waive. However, if you receive confidential information or have confidential information, such as a privileged communication, that would be the city's right to waive it. So if you have confidential information, such as legal advice from me or anybody else from the city attorney's office, that would probably be the city who could decide whether that privilege could be waived, whether that privileged communication could be released to, someone other than the recipient of that information.
And Ms. Muddakerman, on your previous slide about the intro to IPRA, I assume, although I've never yet had this experience, that there could potentially be a request for our own communications if they were relevant to a case, our own emails, text messages, things like that, potentially.
Right. Yeah. Thanks for the clarifying question, because that is what I was getting at, is that if there were emails and text messages pertaining to a case that weren't privileged or subject to some other IPRA exception, they could be IPRA'd.
Thank you.
And so that's it. That concludes the presentation. Like I said, if you have questions about something like a conflict or any other conduct related questions, you're always welcome to reach out to me. If you have other questions kind of generally about planning, about scheduling, you can always reach out to Maggie as well. Or anyone else from the planning staff, but Maggie volunteered to be the contact if you have any other questions. So that's it for the presentation. Are there any other kind of general questions about anything I talked about tonight?
Is this presentation online?
It's not, but I don't think it is, but yeah, we can email it. Yeah, I'd be happy to.
Very helpful.
Okay, great. Okay. That sounds
Commissioner Smith, do you have a question?
Yes, and not pertinent to much of this, but is there a working definition of quasi-judicial?
There is, yes. So we dealt with that quite a bit recently, because that was an issue that came up in the Area 1B matter, was whether the one of the county's proceedings was legislative versus quasi-judicial. Generally, generally it's going to be a case-by-case analysis, but legislative matters are going to be things of kind of general public interest. So something that affects an entire community, something that's more political. Quasi-judicial is going to be generally a matter that affects one person or a small or discrete group of people, and anything that involves application of law to facts is going to be another factor that would make something quasi-judicial. So if you're interpreting a statute usually that would be something that would make a matter quasi judicial. So basically all of the cases that you have would be considered quasi judicial. I guess there could be some situations where a rezoning could be legislative instead, like a recommendation to approve a rezoning, just if it's a big enough area, or if it's, for a whole section of the city or something like that, depending on why it's being rezoned. But generally, the cases that you see are going to be quasi judicial.
Or the meetings that we potentially will have about any recommendations to changes to the land use code, those would be legislative whenever we get to those.
Yeah, I would think so. Yeah.
It doesn't speak to a broadly defined use of discretion on the part. We're deciding something. It has to do with the type of decision that would come before us. Either it's a legislative rarely, or it is having to do with a more specific and discrete issue, in which case, because what I found confusing is what's the role of the staff? People are paid to come and tell us what they think the right thing to do is.
Mhm.
And then we have other people saying they think something else is the right thing to do with. And I was thinking of judicial as deciding between the two arguments.
Mhm.
But in fact, it's more about the nature of the decision being made, not that, because in general, we would support the staff unless we thought the staff had not collected enough information or had reached a dramatically incorrect conclusion.
Yeah, and I guess I would, right. So it's more about the decision that you're making than about the process used to use it. So there is case law about that where parties have argued that a process appears to be more trial-like. And generally the courts have said that the process isn't really what you're looking at so much as the type of decision. And I guess I just wanted to note as well that when you hear, I think that a lot of times you hear basically an applicant and staff, so it kind of seems like there's like staff is kind of taking the role of a party. Generally, staff isn't the recommendations that they're making aren't really argument or in defense of a particular position so much as advisement. So I think that sometimes we do have situations where it's more like two parties. I guess I'm trying to think, like if you had an appeal hearing where you somehow had an applicant and someone that was opposing the application, I think that would be hard because a lot of the appeal hearings that you would hear would mostly be land use director decisions on a permit or something. But in those situations, there are two parties. But the idea is that staff is supposed to be making a neutral recommendation.
Any other questions from any commissioners? All right. Anything else from staff?
No, thank you. Thanks, Commissioner Lawrence. I just want to thanks Rebecca for coming in tonight and thank you for your questions. And yeah, if you have additional, requests to, dig deeper into any of these issues or into any other issues that we haven't covered before, I'd be happy to, schedule that and get, someone to come and speak specifically to those issues so we can get into it a little bit more. I was thinking too, I was talking with Dan Escabel and he wanted to, kind of schedule some time to just come talk about development plans and, subdivisions and just generally, so we can really dig into those sections of the code and, and understand, what we're looking at when we review applications and kind of pull back the curtain a little bit for you guys so you can, understand what goes into, our recommendations and our review.
I've said before that understanding the open space section of the code is something that has always puzzled me myself.
Yeah, no,
Right.
that is
A lot of
a
times
tricky
it's not.
one. There's a lot there, yeah.
Commissioner Wheelan, did you have something?
Mhm.
Yeah, with the update of the code, I mean, do you feel that
Mhm.
that's gonna, I mean, I shouldn't say relevant, because it is relevant. 'Cause it's
Yeah.
good to have the history of it as well, so you don't make mistakes. But obviously, anything that Dan presents to us will be in the process of change.
Yeah. I mean, we probably won't stray too far from, certain, I mean, a development plan is a development plan. But yeah, we are going to be updating it certainly. But I still think, I think we can get some value out of it. Yeah, for sure. So.
Yeah. Anything else? Any other matters from the commission before we adjourn? All right. Thank you all. Yeah, thank you.